Waverly had watched her parents make a lot of choices over the years. She had watched them choose appearance over substance, comfort over responsibility, and the version of every story that made them look best over the one that was actually true. She had grown up understanding that in her family, the narrative mattered more than the reality, and that maintaining the narrative required a specific kind of selective blindness that her parents had been perfecting for decades. But this was different. Her grandmother Eleanor had spent 40 years building something real: a house, a savings account, a carefully tended life that she had managed with the discipline of a woman who understood that security was built slowly and protected deliberately. She had raised her children in that house. She had buried her husband in the town where she had lived for 50 years. She had grown old with quiet dignity. Then her health began declining, and Waverly's parents stepped in to help. Help, as it turned out, meant something very specific in their vocabulary. It meant joint account access. It meant $3,850 spent on a resort weekend Eleanor had never been told about. It meant a 79-year-old woman sitting in a cold house in January in two sweaters because the heating bill had been paid late again, while her son posted spa photos online. Waverly had driven to Eleanor's house on that Sunday in January and found her grandmother exactly that way. She had driven home and called an elder law attorney Monday morning. And what she built over the next 4 months changed everything about who was in control of Eleanor's life. Before that judge grants the petition and suspends her parents' account access, hit subscribe right now. Because the moment Eleanor tells the judge she never authorized that resort trip is something nobody in that courtroom was ready for. New videos every week. Hit like if you have ever watched someone vulnerable be failed by the people responsible for them. Drop a comment. Have you ever had to step in for someone who couldn't protect themselves? Now let's go back to Richmond. Because Waverly just found her grandmother in two sweaters, and she is already dialing the attorney. My name is Waverly. I am 29 years old and I live in Richmond, Virginia. My grandmother Eleanor has been the most consistent relationship of my life, not in a complicated or dramatic way, just in the specific, reliable way of a person who was always genuinely glad to see you and always had something real to say when you arrived. I had been visiting her my whole life, as a child because my parents brought me, as a teenager because I chose to, and as an adult because the visits had become something I organized my own schedule around. Eleanor was 79 years old and had been managing her health decline with the quiet dignity she brought to most things, carefully, without complaint, with the grace of someone who had made peace with where they were and was tending it well. 18 months ago, Eleanor's doctor had recommended she have more consistent support in her daily life. Nothing institutional, just the presence of family who could help manage appointments, medications, and the ordinary logistics that had become harder to navigate alone. Waverly's parents had stepped forward. Her dad was Eleanor's son and had presented the arrangement with the warm language of family responsibility. They would establish a joint account to manage Eleanor's household expenses. They would coordinate her medical appointments. They would make sure she was not navigating things alone. The family had received it as good news. Waverly had received it as probably good news. She had wanted to believe the best version of what was being offered. She had visited regularly and watched carefully, and had told herself the unease she felt was unfounded. She arrived at Eleanor's house on a Sunday in January at 2 in the afternoon, unannounced, the way she usually arrived, because Eleanor had always said she preferred people who showed up over people who scheduled themselves. The front path had a thin layer of ice that hadn't been salted. She knocked, and Eleanor called her in from somewhere in the back of the house. She found her grandmother in the sitting room in a cardigan and a heavier sweater layered on top, dressed for cold in a house that should have been warm. The thermostat on the wall read 61 degrees. Eleanor smiled when she saw her and said she had been just about to put the kettle on. She said it with the specific cheerfulness of someone who had decided not to make her situation a burden on the person who had just arrived. They sat with their tea and Eleanor talked about her week, a phone call with an old friend, a television program she had been following, the neighbor's dog that had taken to sitting near her back fence in the afternoons. Waverly listened and waited and eventually asked about the heating, whether there had been a problem with the system or whether it was something else. Eleanor said it was probably just a timing thing with the account, that sometimes things ran a little low between her son's payments and that it sorted itself out. She said it casually, in the tone of someone describing a minor inconvenience rather than a pattern. She said she was sure it would be fine. She offered Waverly more tea. Waverly accepted and held the warm cup and sat with what Eleanor had just told her and what she had not said. She drove home through the gray January afternoon and pulled into her apartment parking lot and sat in the car with her phone. She opened her dad's social media, something she checked occasionally without particular purpose, and scrolled back 4 days. The photos were there. A resort property she didn't recognize. Her dad and mom at what appeared to be a restaurant with cloth napkins and candles. A spa treatment photo her mom had posted with a caption about treating herself. A poolside photo from what the geotag identified as a resort property 40 miles from Richmond, posted 4 days ago, while Eleanor's heating account was running low. While Eleanor was layering sweaters in a 61-degree house and telling her granddaughter it would sort itself out, she looked up the resort that evening, found it from the geotag location and the visual details in her parents' photos. She found the weekend rate on the booking page. She added the restaurant charges that matched the style and price point visible in the photos. She added a reasonable estimate for the spa service her mom had posted about. She found a figure that she checked twice because she wanted to be precise rather than approximate. $3,850 for a weekend. Posted to social media 4 days before she found her grandmother in two sweaters in a 61-degree house, assuring her that everything was fine. She wrote the number on a piece of paper and set it on her kitchen table and looked at it for a long time. Then she went to bed. In the morning, she would make a call. She called Patricia Osai's office at 9:15 Monday morning, had found the name through a Richmond legal referral service that specifically listed elder law practitioners. The assistant who answered asked the nature of her concern. Waverly said she had an elderly grandmother whose finances were being managed by a family member, and she had concerns about how those finances were being used. The assistant put her on hold for 30 seconds and came back with an appointment for that same afternoon at 2 o'clock. Waverly thanked her and ended the call. She sat at her kitchen table with the piece of paper that had $3,850 written on it and thought about her grandmother in two sweaters and the specific cheerful tone Eleanor had used when she said it would sort itself out. It was going to sort itself out, just not the way anyone was expecting. Patricia Osai's office had the specific quality of a space that had been arranged to communicate competence without intimidation. Bookshelves with organized files, a desk that was substantial without being imposing, two chairs on the client side that were comfortable enough to suggest the conversations held in them sometimes ran long. Patricia herself was direct and unhurried in the way of someone who had spent 17 years in elder law and had learned that clients who came to her office were already carrying enough weight without having information made more complicated than necessary. She had listened to everything Waverly said without interrupting. The resort photos, the calculated amount, the two sweaters, the 61-degree house, the cheerful assurance that it would sort itself out. Then she opened her legal pad and said, "From the beginning, please." Patricia explained Waverly's legal position clearly and without preamble. As a named beneficiary in Eleanor's existing, Waverly had standing as an interested party in Eleanor's financial affairs. This was not an aggressive legal posture, but a recognized protective mechanism that existed specifically for situations where a named beneficiary had reason to believe an estate was being mismanaged during the beneficiary's lifetime. She said the standing gave Waverly the right to formally request a complete accounting of the joint account, all transactions, all withdrawals, the full 18-month history. She said the request would go through proper channels and would be legally enforceable. She said the records would tell them what they needed to know, and that what they needed to know would determine what came next. She said the first step was always the records. The bank records arrived on Thursday morning, a complete transaction history for the joint account covering the full 8 months since her parents had established it. Waverly sat at her kitchen table that evening with the printed pages, a highlighter, and the specific focused energy of someone who had decided that accuracy mattered more than speed. She worked through every page methodically, identifying the legitimate household expenses first, highlighting them in yellow, setting them aside as the baseline. The grocery charges, the pharmacy, the utility payments on the months they had been made on time, Eleanor's doctor copies. These were real and appropriate, and she noted them fairly. Then she kept reading. The other charges were not hidden. They were simply there, present in the record without particular concealment, apparently entered without concern about being examined by anyone who might look carefully. She spent the weekend building a comparison document. The bank records on one side, her parents' social media history, and other verifiable sources on the other. The resort charges aligned precisely with the dates of her parents' posted photos. She matched the transaction amounts to the resort's published rates, and confirmed the figures within a reasonable margin. A charge at a restaurant 40 miles from Eleanor's house appeared on the same evening her dad had posted a dinner photo with a geotag. The car repair charge, significant, appearing twice in 3 months from the same mechanic, she had verified by calling the shop's front desk and confirming that no vehicle registered to Eleanor had been serviced during either period. Each connection she documented with its source and its verification method. By Sunday evening, the document was 11 pages long. She brought the 11-page document to Patricia the following Monday and spread it across the conference table without editorial commentary. Just the documentation, organized chronologically, with the verification sources noted beside each entry. Patricia had reviewed it with the efficient attention of someone who had examined enough of these cases to recognize a pattern's shape quickly. She said what Waverly had documented was consistent with something she encountered regularly in elder financial exploitation matters: withdrawals structured at amounts and intervals specifically calibrated to remain below the threshold that triggered automatic bank review and notification. She said this calibration was not accidental. She said it indicated familiarity with how bank monitoring systems worked. She said the pattern, combined with the documented misalignment between withdrawal purposes and Eleanor's actual care needs, constituted a significant evidentiary picture. Patricia set her pen down after summarizing the pattern and looked at Waverly directly. She said there were 3 legal tools available given the documentation assembled and Waverly's relationship to Eleanor. The first was a formal complaint to Adult Protective Services, which would trigger a state investigation, but would place the outcome in the hands of an agency with a substantial existing caseload and an unpredictable resolution timeline. The second was a civil action against her parents for financial exploitation, which would address the money that had been misused but would not change who held authority over Eleanor's ongoing care and finances. The third was a petition for guardianship and conservatorship, which would place Waverly in a position of legal authority over Eleanor's personal care and financial management, replacing her parents in that role entirely. Patricia said it was the most comprehensive option and the most demanding one. Waverly had listened to all 3 options with the complete attention she had been giving everything Patricia said since Monday afternoon. When Patricia finished, she said, "The third one." Patricia looked at her for a moment and walked through what the third option required: the documentation standards, the court process, the timeline, the family disruption it would produce when her parents were served. She asked if Waverly understood what she was committing to. Waverly said she did. She said she had driven to her grandmother's house on a Sunday in January and found a 79-year-old woman in 2 sweaters in a 61-degree house because the heating bill had been paid late while her son was at a resort spa. She said she was not interested in the options that partially addressed what had happened. She said she wanted the option that made sure it could not continue. Patricia picked up her pen. She said they would start building the petition immediately. Waverly began visiting Eleanor every week starting the Monday after she retained Patricia, not as a change in her existing pattern, which had already been regular, but as a deliberate and documented practice. She brought a notebook. After each visit, she sat in her car before driving away and wrote dated entries: the temperature of the house when she arrived, the state of Eleanor's medications, the contents of the refrigerator, the general condition of the property, whether any family member had been present or had apparently visited since her previous week's entry. She did not tell Eleanor she was keeping the record. She did not want Eleanor to feel observed or managed. She simply wanted an accurate dated account of what Eleanor's daily reality looked like over an extended period of consistent observation. On her 3rd weekly visit, Waverly noticed that Eleanor's primary heart medication bottle was nearly empty, and when she checked the prescription label, the fill date was only 22 days prior. A 30-day supply running out in 22 days. She noted it in her journal and said nothing to Eleanor beyond making sure a refill was called in. The following month, the same thing happened, 24 days this time, still short of the 30-day supply. She brought both observations to Patricia at their next meeting, and Patricia had been quiet for a moment before responding. She said the pattern could have several explanations. She said she wanted Eleanor's pharmacy records subpoenaed as part of the petition documentation. She said it was a detail that would need to be fully understood before the hearing. Patricia had recommended Waverly speak with Eleanor's primary care physician, not to solicit an opinion about the family situation, but to understand the medical picture, and to give the doctor an opportunity to share anything he had observed in a clinical context. Waverly called Dr. Marcus Webb's office and was given a phone appointment for the following week. Dr. Webb had been Eleanor's physician for 11 years. He had been careful in the call, professional, measured, clearly aware of the sensitivity of the conversation. But he had said enough. He said he had noted inconsistencies in Eleanor's medication adherence over the past several months that he had not been able to explain through Eleanor's own account. He said he had concerns about the oversight of her care that he had not previously had a clear avenue to raise. He said he would provide a supporting statement. Patricia subpoenaed the account records from Eleanor's heating company as part of the petition documentation, the full payment history for the previous 12 months. The records arrived and told a specific story. 6 late payments in 8 months. Not dramatically late, between 8 and 19 days each time, but consistently late and consistently occurring in months where the bank records showed the joint account had carried sufficient funds at the time the bill was due. Waverly sat with both sets of records side by side, the heating company's payment dates and the bank account's daily balances, and the picture was clear. The bills had not been paid late because the money wasn't there. The bills had been paid late because the money was there and had been used for something else first, and the heating bill had waited. Leaner's neighborhood was the kind of neighborhood where people had lived in their houses for a long time and had developed the natural awareness of each other's patterns that came from decades of proximity. Patricia had asked Waverly whether there were neighbors who might have relevant observations. Waverly had thought of 2 Margaret Holloway next door who had known Eleanor for 30 years, and a retired man named Carl Briggs across the street who kept irregular hours and was frequently home during the day. She had approached both of them carefully, explained that she was trying to make sure her grandmother had proper support, and asked whether they had noticed anything about Eleanor's daily situation that concerned them. Both had said yes. Both had agreed to provide written statements. Both described extended periods where Eleanor had appeared to be alone without any family presence or check-in. Patricia filed the guardianship and conservatorship petition on a Thursday morning in late April, 4 months after Waverly had walked into her office with resort photos on her phone and a piece of paper with $3,850 written on it. The petition was comprehensive: the bank records, the map transaction comparison, the pharmacy records, Dr. Webb's supporting statement, the heating company payment history, both neighbor statements, and Waverly's 4 months of dated weekly visit journals. Patricia had organized it into a document that told a clear and sequential story, not an emotional story, not an accusatory one, just an accurate one with dates and amounts and verified sources at every point. She named Waverly as the proposed guardian and conservator. The court scheduled a hearing for 3 weeks out. That same afternoon, a process server delivered copies to Waverly's parents. Her dad called at 6:47 that evening. She knew the exact time because she had been sitting at her kitchen table when the phone rang and had looked at the screen and made a deliberate decision not to answer it. She let it ring through to voicemail. He left a message. She could hear it was long from the voicemail notification, but she did not listen to it that evening. She opened her documentation file and added a new entry: date, time, incoming call from her dad following service of the petition, call not answered, voicemail received and preserved. She saved the voicemail to a separate folder on her phone without listening to it. Patricia had told her early in the process that all contact from her parents following the petition filing should be documented, and that she was under no obligation to respond to any of it. She closed her documentation file and made dinner. Waverly arrived at the courthouse at 8:30 on a Thursday morning. The hearing was scheduled for 10, which gave her 90 minutes to sit in her car in the parking garage and go through the documentation file one final time. Not because she was uncertain about its contents, she had been through every page enough times to know it completely, but because the specific act of reviewing it one more time gave her the particular steadiness of someone who had done the work and was now simply waiting to present it. The file was 3 inches thick. It had taken 4 months to build. Every page had a source. Every claim had a verification. She closed it at 9:15, picked up her bag, and walked into the courthouse with Patricia beside her. Her parents arrived at 9:40 with their attorney, a man Waverly didn't recognize who carried himself with the specific confidence of someone hired to make a problem go away efficiently. Her parents were dressed carefully, her mom in the kind of outfit that communicated with responsible family members without requiring effort, her dad in a jacket that was appropriate for the setting without being formal enough to suggest he had taken the proceedings particularly seriously. They took their seats on the opposite side of the room without looking at Waverly directly. Her dad said something quietly to their attorney, who nodded and made a note. Her mom arranged her bag under her chair and looked at the front of the room. The confidence in their posture was genuine. They had clearly arrived expecting a straightforward morning. The judge was a woman named the Honorable Christine Mallory, 60-something, unhurried, with the specific quality of attention that came from spending years in a courtroom where the difference between careful reading and careless reading had real consequences for real people. She had received the petition documentation in advance and had clearly read it. Waverly could tell by the way she moved through the preliminary review, pausing at specific sections with the recognition of someone returning to passages they had already marked rather than encountering them for the first time. She asked two clarifying questions of Patricia during the preliminary review, both specific, both directed at sections of the bank record comparison that Patricia answered with the documentary references already in the judge's file. The judge made notes. She did not appear to be in a hurry. Her parents' attorney opened with the framing she had anticipated, that the petition represented a mischaracterization of a loving family's genuine caregiving efforts, that the withdrawals cited in the documentation had been made with Eleanor's knowledge and authorization, and that the petitioner's concerns reflected a misunderstanding of how the joint account arrangement had been structured and communicated within the family. He said Eleanor was fortunate to have a son and daughter-in-law who had stepped forward when her needs increased. He said the petition was unnecessary and that the family was capable of resolving any communication gaps without court intervention. He said it smoothly and with the practiced confidence of someone who had made similar arguments before and had found them sufficient. He sat down. Patricia stood up. Patricia presented the documentation without drama and without editorial commentary, page by page, source by source, in the sequential order Waverly had watched her organize it over 4 months. She walked the judge through the bank records and the mapped comparison document, the resort charges aligned with the posted photos, the restaurant charge with the geotag, and the car repair charge verified against the mechanic's records. She presented the heating company payment history, alongside the daily account balances, showing specifically that funds had existed on each due date and that the late payments had not been caused by insufficient funds. She presented Dr. Webb's statement, the pharmacy records showing the prescription gaps, both neighbor statements, and 4 months of Waverly's dated visit journals. She presented it all in 40 minutes. She did not raise her voice once. Eleanor had been brought to the hearing by Waverly's arrangement. Patricia had said her presence was not required, but that it would be significant if she chose to attend, and Eleanor had said she wanted to be there. She sat in a chair to Waverly's left throughout the proceedings, composed, attentive, following the documentation presentation with the focused attention of a woman who was hearing certain things clearly stated for the first time. When Patricia finished, the judge looked at Eleanor directly and asked her several specific questions. She asked whether Eleanor had been aware of the resort trip. Eleanor said she had not. She asked whether Eleanor had authorized the withdrawals listed in the comparison document. Eleanor said she had not authorized several of the larger ones. She said it clearly and without hesitation. Her son's chair scraped the floor. Judge Mallory took a 30-minute recess after Eleanor's responses. Waverly sat in the hallway with Patricia and did not speak much. When the judge returned, she delivered her ruling with the measured directness of someone who had reached a clear conclusion and was stating it precisely. She said the documentation presented supported a finding that Eleanor's financial interests had not been adequately protected under the existing arrangement. She said the petition met the legal standard for appointment of a guardian and conservator. She appointed Waverly as Eleanor's legal guardian for personal care decisions and as conservator of Eleanor's estate effective immediately. She ordered the joint account restructured and her parents' access suspended pending a formal accounting. She said the accounting was due within 30 days. She asked if there were questions. There were none. The hearing was adjourned. Waverly left the courthouse at 11:45 and called Patricia from the parking garage before starting her car. She asked what the first step was. Patricia said the account restructuring needed to happen within 24 hours of the order being filed. She said her office would send the court order to the bank directly that afternoon and that Waverly should be available to sign the new account authorization documents by end of business. Waverly said she would be available. She ended the call and sat in the parking garage for a moment, not processing dramatically, just sitting with the specific quality of a morning that had produced something real and permanent after 4 months of careful building. Then she started the car and drove to Eleanor's house. She wanted to be there when the bank confirmation came through. She wanted Eleanor to know it was done. The pharmacy situation was the second thing she addressed the following morning. Before anything else on the list, Patricia had helped her build immediate conservatorship priorities. She called Eleanor's pharmacy and established a new management protocol: monthly delivery to Eleanor's house, automatic refill triggered 5 days before the end of each prescription cycle, all billing routed through the new conservatorship account rather than the restructured joint account. The pharmacist confirmed the setup and said Eleanor's next delivery would arrive Thursday. Waverly added the confirmation to her conservatorship file and noted the date. The 3-day gaps at the end of every month, the gaps that had appeared in the pharmacy records and had become part of the petition documentation, were not going to happen again. She moved to the next item on the list. She called the heating company on the same Thursday morning, identified herself as Eleanor's newly appointed conservator, provided the court order documentation the company's account department required, and established automatic payment from the conservatorship account on the 15th of each month, regardless of the balance in any other account. She asked the representative to confirm the current balance owed. She paid it that afternoon through the conservatorship account. She asked for a written confirmation of the automatic payment setup and received it by email within the hour. She printed it and added it to the conservatorship file. Eleanor's house had been cold in January and cold again in February and had run uncertain through March and April while Waverly built the case. It was now the second week of May. The house was going to stay warm. That was not going to be a question anymore. They arrived on a Saturday afternoon, her dad's car in Eleanor's driveway, when Waverly pulled up for her weekly visit, which she had continued without interruption through the hearing and its aftermath. She parked behind them and walked to the front door and found her parents in Eleanor's sitting room, her dad standing near the window, her mom on the edge of the couch, both of them with the slightly off-balance quality of people who had arrived expecting one version of an interaction and found the furniture rearranged. They had not called ahead. They had not contacted Waverly through the proper channels Patricia had established for family communication with Eleanor. They had simply arrived, expecting, apparently, that arrival still meant access. Waverly set her bag down and said hello to Eleanor first. Then she looked at her parents and said she was glad they had come, that there were some things that needed to be discussed. Waverly had not planned what happened next, had not scripted it or prepared Eleanor for it, or positioned the conversation in advance. Eleanor had simply been present and had decided, in the specific way she decided things that mattered to her, that she wanted to speak. She looked at her son and her daughter-in-law from her chair in the sitting room and said, with the calm directness of a woman who had been waiting for the right moment and had recognized it, that Waverly was managing her affairs now. She said she had been to the courthouse. She said she understood what had been in the account and what it had been used for. She said she was not angry. She said it without particular conviction, which was its own kind of statement. She said she was glad someone was taking care of things properly. She said Waverly was that person now. 3 weeks after the hearing, Eleanor called Waverly on a Tuesday evening, not about anything urgent, just the regular call they had established as part of the new weekly rhythm. Near the end of the call, she said she had been thinking about her will. She said she had made it 11 years ago, and that it reflected a version of her wishes that was no longer accurate. She said she wanted to update it, and that she wanted to do it properly, with her own attorney, not the family's existing estate attorney, and with Waverly present when she had the meeting. She said she was not asking Waverly to tell her what to put in it. She said she had her own ideas about that. She just wanted someone in the room who was there specifically for her when she said them out loud to a lawyer for the first time. The estate attorney Eleanor had chosen was a woman named Sandra Cho, selected by Eleanor herself from a list Waverly had provided without recommendation or preference. They sat together in Sandra's office on a Wednesday morning in early June, Eleanor in the chair directly across from the attorney's desk, Waverly one seat to her left, present and quiet in the way she had learned to be present without filling space that wasn't hers to fill. Eleanor spoke clearly and specifically for 45 minutes. Her wishes, her reasoning, the people she wanted to provide for, and the amounts she had considered, the specific bequests she had thought about carefully. Sandra asked clarifying questions and made notes and treated Eleanor with the complete professional respect of someone taking instructions from a client who knew exactly what she wanted. Waverly sat beside her grandmother and said nothing and thought about a Sunday in January, and 2 sweaters and 61 degrees, and the specific cheerful voice that had said it would sort itself out. It had, just not the way anyone had expected.